phone turn off.
Any matters that we would like to take up prior to Mr. Baker being drawn out?
First off, there's nothing that's taken up outside the presence of your client in a death penalty case, so if it's taken up, it'll be taken up in this courtroom. If it has to do with the cameras, I've reread the rule again. Nobody has to give you notice of any approval prior to my approving cameras in the courtroom. If you read the rule carefully, they have a right to be here as long as I give them permission to be here, unless I otherwise order it or the Supreme Court has a different rule, which they do not. You received the introduction there?
I do, Your Honor. That's what I'm reading right now.
You understand it? Unless another rule of the Supreme Court, I don't have the exact verbiage, but or unless otherwise ordered after a hearing. They have the right to be here. That's what it says. And I've just read it 3 times.
I understand, Your Honor. We would just...
Now, if you file a motion for future hearings and you don't want them to be here, you have to file the motion, serve the other side. I get notice, we'll have it set up for a hearing. Your client will be here during that hearing, at which time you argue why they should be excluded and you make the case under the rules and under the Constitution, how and why they should be excluded. All right? Otherwise, they will be here when they file the proper Rule 22 with the court that does not require notice to either side. Okay?
I understand, Your Honor.
If that's what it was, I'm just guessing.
It is, Your Honor. Just for the record, we would object.
All right, this is the 2017 SUCR 73, the Superior Court of Henry County, State of Georgia versus Matthew Baker Jr. We're here as a result of the death penalty notice being filed by the district attorney stating his intent to seek the death penalty in this case. Under the Unified Appeal process, a hearing has to take place, at which time we go through the preliminary matters that we have to state, and we'll start out with the notification. Mr. Patillo, if you'll identify yourself on the record.
Yes. Gary Patillo, District Attorney, Henry County, Clinton District.
And your Chief Assistant.
Yes, Your Honor. Should be in the case.
All right, and Defense Counsel, who is going to be lead counsel?
That would be me, Your Honor. Good afternoon, Kimberly Staten-Hayes on behalf of Mr. Baker. Good afternoon, Judge. My name is Sheila Galloway, also on behalf of Mr. Baker.
And good afternoon, Your Honor. I'm Christina Rudy on behalf of Mr. Baker.
All right, I'm going to find, I know I've got it, your entry of appearance. And let me make sure I put lead counsel, Ms. Hayes. That's you, right?
Yes, Judge.
All right. And Ms. Galloway, I'm going to make sure I put a name and a face together and try to memorize this. You Miss Rudy.
Yes, Your Honor.
Is that how you pronounce it, Rudy?
That's correct, Your Honor.
All right. So we have been identified, and Mr. Matthew Baker Jr., I recognize you from prior time in the courtroom. Mr. Baker is present. I'm going to go down the checklist, and I'm starting on page 4. First paragraph, really not much to do there. The state's already filed its notice, and that's why we're here, as there been service upon the defense.
We have not received a copy of any death notice in the case, Judge.
They have not, Judge. I'm prepared to do that now.
Right.
As when we last met on March the 21st, 2017, this year, Mr. Baker was present in court. He was not represented by counsel at that time. The state was not aware of who his counsel was at that time. It's also my understanding that he had not been appointed counsel at that time. So that's why the defense counsel does not have notice of the state's intent to seek the death penalty. However, we're prepared to do that right now in open court. I'm going to first give Ms. Staten-Hayes a copy of our original notice, which was filed on March the 21st, 2017. I did, in fact, serve her client on March 21st. Right. I served him with the state's notice of intent to seek the death penalty here in open court. We also, at that time, gave him a copy of the Unified Appeal Procedure. We also notified him that he should give those items to his lawyers. But I'm going to give them the first notice of intent.
Thank you.
I'm also giving her a copy of the Unified Appeal Procedure. At this time, the state would also like to serve Mr. Baker and his counsel with the amended state's notice of intent to seek the death penalty, where we have added some aggravating circumstances. That was filed today, April 11, 2017. I'm going to hand Ms. Stanton-Hayes a copy as well as her client.
All right. All right. Service of the intent to seek the death penalty and the amended aggravating circumstance notice has been served. The defense counsel has already been identified, and we will go through one at a time. Ms. Stanton Hayes, if you will, I believe it's obvious that y'all are appointed, so that's very simple, but the qualifications that you have.
Yes, Judge. Your Honor, as lead counsel, I am a member in good standing with the State Bar of Georgia, have been so since 1994. I have 23 years combined of criminal litigation experience, both as a prosecutor and as a defense attorney. With regard to paragraph 2, I have tried in excess of 50 murder trials as a prosecutor, as the lead attorney, and I have sat as second chair on 3 death penalty trials as a defense attorney. I am familiar with the Unified Appeal Procedure. I am familiar and experienced in the utilization of expert witness and evidence, including but not limited to psychiatric and forensic evidence. Within the 12 months prior to today's date, Your Honor, I have had at least 10 hours of specialized training in death penalty defense, and I have demonstrated, I believe, the necessary proficiency and commitment to exemplify the quality of representation appropriate to capital cases, and I believe that I am qualified to serve as the lead counsel for Mr. Baker.
All right, thank you. All right, Ms. Galloway.
Good afternoon again, Judge. Pursuant to UAP Rule 2A1B, I list the following as my qualifications to act as co-counsel. I am a member in good standing of the State Bar of Georgia. I have practiced criminal law exclusively since being admitted to practice in November 2004. I have been co-counsel in at least 1 murder trial to verdict, State versus Desiree Jackson, DeKalb County, and at least 2 felony jury trials, State versus Nicole Williams, DeKalb County, and State versus Carrie Price in DeKalb County. I have been co-counsel in a death penalty case to verdict, State versus Charmon Stanfield. I have attended within the last 12 months at least 10 hours of specialized training or educational programs in death penalty defense. I attended the annual Death Penalty College training in August 2016 at Santa Clara University College of Law in Santa Clara, California.
Thank you. Ms. Rudy.
Good afternoon, Your Honor. Pursuant to UAP Rule 2A1B, I am a member of, in good standing with the State Bar. I have at least 3 years of criminal trial practice. I have been barred in Georgia since 2011 and have exclusively practiced criminal law during that time. I have been lead or co-counsel on at least 1 murder case and 1 death penalty murder trial. And I have also been lead or co-counsel in 2 felony jury trials. During the last 12 months, I have attended training specific to death penalty cases, and I will continue to attend that training during the time that I represent Mr. Baker. And I believe that I'm qualified to serve as co-counsel for Mr. Baker.
All right, thank you. Now, I separated the defendants in this case for the purpose of this proceeding, and will probably continue to do that, especially if a motion for severance is filed. And granted, obviously it'll be done, but that'll be coming up on the checklist. But because y'all are with the Metro Capital Defender's Office, and I sit on the Public Defender's Council, if there's an objection from either the state or the defense, I don't know that there's any problem with that, and the previous co-defendant did not have a problem, but Mr. Baker, not Mr. Baker, but Ms. Stanton Hayes, and you or Ms. Galloway, Ms. Rudy, have any objection to me presiding over this proceeding?
No objection, Judge, to Your Honor presiding on this matter.
All right, thank you. And from the state?
No objection.
All right. Let's see. Now, copies of the procedure have been given to Ms. Stanton Hayes, so she has her copy. Court reporter has already previously gotten a copy, I believe, on the 21st of March. You're instructed to read and adhere to these provisions, and having heard at least two of the three of y'all with your prior history, you probably could recite this stuff to me, but I'm going to read it by the book. I found that it's less likely for me to make a mistake if I read word for word. A copy is also be given to the court reporter, and the reporter is reminded that she is to be, everything in this case to be completely transcribed as set forth in the Rule 4A. The defense counsel is informed and instructed that the outline and checklist are intended to assist you in protecting the defendant's rights, but it remains the responsibility of the defense counsel to protect those rights. The outline and checklist do not take the place of a diligent counsel actively representing the defendant. Defense counsel is also reminded of the defendant's option to invoke the provisions of Georgia's Criminal Procedure Discovery Act, OCGA Section 17-16-1 ETSEQ. If the defendant elects to participate in reciprocal discovery, both parties shall be reminded that the information provided shall be accurate, complete, and updated as needed.
And for the record, Judge, Mr. Baker opted in on April the 3rd, 2017.
All right, Mr. Patillo, do you need to have anything on the record on that?
We are prepared to serve them with discovery today. I can do that at this time. I can do it after court.
Let's go ahead and do it now.
Do that now.
This seems to flow logically. They've opted in and you've got discovery.
Yes, Judge, I'm going to go through this for the record. I'm about to hand serve Mr. Baker and his lawyers with the discovery in this case. That includes the entire police case file. There are 61 CDs and or DVDs and 8 flash drives. The entire police case file at this time has about 928 pages and contains all the police reports and statements, video, audio, as well as other evidence. And over the course of this trial, we will definitely supplement the discovery as necessary, and we will always make our file available to the defense and the defendant when scheduled. We would also make sure we'll want to request that we get reciprocal discovery. So at this time, I'm going to hand serve counsel with all of the discovery.
All right. Okay. Now, the court is also required to remind you if you intend to challenge the array of the grand jury or the traverse jury, the court needs to be informed about that by way of motion. Do you intend to challenge the array of the grand jury at this time?
Yes, Judge, we would be filing that challenge.
All right.
For the record, the traverse jury too, ultimately we will challenge both.
All right. And also, it's obviously early to try to challenge the traverse jury since we don't have one, but essentially, since this earlier proceeding with the co-defendant, they also intend to challenge the array of the grand jury. It might be something that could be done together. That might be one motion we could actually do together and have a hearing unless there's a severance, and that still would not change the grand jury. The grand jury would remain the same even if the case is severed. So they also intend to do that, so it might be a good idea to, you're more than welcome to come on up.
I wanted to make a quick inquiry, Judge.
Okay.
I neglected to come to the podium last time I spoke.
All right.
As far as the jury certificate, is that available for us today?
I don't think so. Ms. Harrison is not aware that, as of right now, she now knows that you're going to do this. And so Ms. Harrison, Ms. Barbara Harrison, the clerk, she will get you what she needs to get you. And we'll make sure that it's provided timely. If we need to have a hearing, this is the one hearing in the co-defendant's case that we think we might get before they start a jury trial on another death penalty case. And in that regard, since scheduling is rather difficult for the capital defender's office because you have a number of death penalty cases which fight among each other, but you only can do them as the oldest case is the one we get to. So I would like to have some Mr. Gardner is going to provide me a list of the death penalty cases he currently has and what stage they're in, essentially, what's coming up next and when they're scheduled. And he said he would get it to me tomorrow. If you can't do it that soon, that's okay. If you can get it sooner than that, like right now, I'll take it now.
Can't get it to you quite that soon, Judge, but should be able to get you that list by tomorrow. Is email acceptable?
Email will be fine. I'll be giving you that address later.
Thank you.
The idea is that we will be able to more easily do what the only thing we can do outside the presence of your client, and that's scheduling. We can do that, and with an idea of what you have, I'm looking at the long-range game plan here, and I felt like that once I get Mr. Gardner's schedule, I'll know, well, that case that he just took to trial in July took him so many years to get there. I figure I'm going to be that many years back getting this one, because I don't, unless something happens in between, and things do happen. But it will help me a little bit to have that knowledge. So when you say, well, Judge, I got a conflict with this case, I'll know what it's about, where you're scheduled, and things like that. And don't let me forget to give you the email address. I will do that later. So we're at to count number 5. We already covered the grand jury and the traverse jury. It's too early to do that. Has your experience in the challenging the array of the grand jury under, and I will quote it as the new jury rules, been that Mr. Gardner's experience was that it takes a day or less to have that?
Judge, in my experience, and even thinking back to the one that we did, I believe in 2015 or so in Henry County, typically we'll have 3 or so witnesses. The state will typically have the various, the jury clerks and maybe 3 or 4 witnesses. So typically it is at least a 4 to 6 hour type of hearing.
That's after having Mr. Gardner make that statement, and anticipate it would be the same. I just want to make sure that that is clear, so we can do that. And we will certainly do that as soon as possible. And Mr. Gardner had a case, as I said, starting in July. Do you have anything that would prevent us from doing some work on this part of the case, this co-defendant, in July? Do you have a trial?
Judge, we have a client in Clayton County who has 2 separate death penalty cases. We begin, and those are cases from 2010. We have motions starting, we've got motion dates in August, September, and I believe October. We anticipate that would probably be one of his cases, would probably be the next case that would go out to trial. I'd say between the 3 lawyers, and we'll short it up in the email, but I think we have between us maybe 6 death penalty cases, Judge.
Okay. Well, once we get your case schedules, we'll be able to tell. All right. And whether or not there's a challenge, but there's going to be a challenge, so I don't have to review the certificates, although I will. That's just because I will review everything in the file in this case. Okay, Mr. Baker, we're down to number 7 on page 4. I know you may not have a copy. If you do, we follow along. This is the time when I ask you if you have anything to say about any objections to your defense counsel or to the manner in which defense counsel have conducted or are conducting your defense up until the present time. Okay, well, you're giving an opportunity to answer, and you're refusing to answer for constitutional reasons. I'm not sure where that is. I've read the Constitution, haven't found it yet, but y'all follow the counsel. One thing, you obviously like the counsel given you by your lawyers, or you wouldn't be following them. So they must now take that as a positive. All right, we will now go to page number 14, the pretrial checklist. And in Mr. Kosky's case, Mr. Gardner said they just got served with discovery, and he said it's impossible for me to address each and every one of these without having reviewed discovery. And the only thing that I brought to his attention that I would ask for him to address as quickly as possible was on page 16, subsection J. It's at the top of the page. If anything under that section is going to be an issue, the sooner the better.
Yes, Judge.
I don't like to broadcast all that, but you know what it is, and the record will reflect what I'm referring to. But as far as the other issues of the arrest, the search warrants, if any, identification of the defendant, confessions, admissions, if any, representation by counsel, any other demurs, motions to quash special pleas, arraignment, plea and bar, all of those, just having gotten discovery, I don't know how you could even say one way or the other.
Judge, just
That's all right. There you go.
for the record, Judge, As the court is aware, we were just served with the discovery today, but with regard to all of the different subsections in that checklist, we would anticipate filing numerous motions on behalf of Mr. Baker to make sure that his rights are protected from search and seizure, from evidentiary issues to indictment issues, but we do intend to cover the gamut within that checklist.
Thank you. Obviously, Section 9 on page 5, I'm skipping back to that. I have to inform you not to fail to interview all persons whose testimony might be helpful in discovering or supporting available theories of defense or mitigation of punishment. And it's now time for arraignment and the plea on the merits of the case. Are you ready for arraignment?
Your Honor, we are prepared for arraignment. We would waive any formal reading, and Mr. Baker would enter a not guilty plea on the
All right. Mr. Patillo will take care of that.
The original indictment I handed Ms. Stephen Hayes now.
The document has been signed by Mr. Baker, evidencing his not guilty plea, as well as by his three attorneys.
All right. So that brings me down to the end of this proceeding, subject to anything you wish to bring up that needs to be addressed.
And while they talk now, approach them.
Certainly. Thank you.
Your Honor, at this time, the defense has nothing else with regard to the first proceeding and the arraignment of Mr. Baker.
All right. Mr. Patillo, anything?
Nothing else from the state court, Judge. Thank you.
All right. The address for contact with the court is McGarity Chambers at co.henry.ga.us.
One more time, Judge. Please.
McGarity Chambers, with plural, at co.henry.georgia.us. CO stands for county, Henry is the name, GA is the Georgia, and US is the country.
So McGarity Chambers, this is one.
One word, all together, no spaces.
And you will have an email tomorrow. Do you want us to CC this to any member of your
Yes. She will give you her address. That is Vanessa Eccles. That is my law clerk of, I think it's 13 years. It could be only 12 and a half. But she's been with me a number of years. And I want her, she is handling the law clerk duties on this case. And she will be a point of contact when I am on the bench and unavailable. She will be copied with everything that you have. On my address, the McGarity Chambers, she has a separate one she'll give you, that way you can copy her. But as I told Mr. Gardner, Mr. Patillo is already on my I can get emails from him list. We will add y'all to that list so that you can get through and not get bounced back. If you do get a bounce back, that's only because you haven't been entered into the database yet to be accepted. But you will be accepted probably within the next 10 minutes as soon as I get off the bench.
Thank you, Judge.
And last but not least, Mr. Baker, do you have any questions about this proceeding at all? You don't have to say anything if you don't want to. At the end of every proceeding in a death penalty case, and I've handled a few, I'd just like to make sure that the defendant has a question on his mind. If it's one better addressed by the court, I will do it. If it's one better addressed by your lawyers, I'll tell you. They can tell you about all that. Any questions?
Yes, sir.
Okay. If you have questions that you need to address the rest of your counsel, when Mr. Gardner in his co-defendant's case made a point that he had an issue with, not an issue, he was afraid it might become an issue of getting able time to be with his client, I gave him the name of David Foster, Chief Deputy at the Sheriff's Department. That person may very well give y'all another person to make contact with. It was the time frame from 10 to 1, I think he said, that there's not visitation allowed, which sort of eats up a day for y'all having to come down, and then you only get an hour or two, then you got to take 3 hours off and then get back. So they will make arrangements to make it an exception possibly in the situation. If it doesn't work out, you'll let me know. I don't think it'll be a problem. Mr. Foster's been around a good while. He used to be the chief deputy here at the courthouse, and so I've known him a number of years, and he's taken care of all my problems that I can imagine I've ever had in regard to the security issue and the contact with people that are being detained. So,
Thank you, Judge. Much appreciated.
all right. Anything else? Court's adjourned for the day. We'll reschedule the next hearing when we find out what it is.
Thank you, Judge.
Thank you. File to you. You might as well go ahead and do an expand though. Yeah, hold that case over and plate again. Did you hear how old that case is?
Yes, I did, but that surprises me because, I mean, just like Judge Stevens, he said that they were trying jury trial after jury trial.
That's what Collier told me. That's what Al told me. Thank you. Anyway.